How does the Biden immigration bill, the U.S. Citizenship Act of 2021, impact business immigration? Welcome to Voice of Immigration. I am your host, John Veely, immigration attorney and CEO of Online Visas, the intelligent immigration platform. Representative Sanchez, a Democrat from California, and Representative Menendez, a Democrat from New Jersey, sponsored the bill, the U.S. Citizenship Immigration Act, on February 18, 2021. It is the first comprehensive immigration bill since 2013. At that time, the Gang of Eight, those were four senators from both parties, introduced a bill for comprehensive immigration reform. Senator Menendez was one of those senators. That bill had no co-author in the House of Representatives. This bill has House of Representatives and senators co-sponsoring the bill and behind the bill, but this bill has no Republicans on board. As the Democrats have the majority in both the Senate and the House, they have a 50-50 tie in the Senate, but they have the tiebreaker with Kamala Harris. However, to pass this bill, Democrats will need to win over 10 Republicans to get past a maneuver called the filibuster, or it could die a procedural death. Those familiar with the bill think that it is dead on arrival. So why are the Democrats doing it if they think that they may lose, especially as Biden's first major piece of sponsored legislation? The answer is a few things. Number one, it's pro-immigrant. There is no surprise that the Trump administration attacked immigrants. The immigrant populations in the United States strongly supported Biden in the 2020 election. In fact, Nevada and Arizona, both states who voted for Trump in 2016, flipped to Biden because of strong immigrant voting populations. Two, it's strong. It said enough of illegal aliens. Anyone in the United States on the day Joe Biden was inaugurated as President of the United States has a pathway to citizenship. In addition, they're getting rid of the word alien as a matter of law. Three, it supports American workers by making sure that fair wages will be paid to foreign nationals. This helps both foreign nationals, but also it appeases labor unions who support both foreign and American workers by trying to deal with an issue that has been at the crux of immigration, and that's whether or not foreign nationals are underpaid. This had been a big piece of the Trump administration, but the way the Trump administration handled it was to make the foreign national wages so high that no one would hire a foreign national. This one will be the big debating point between a couple of different major players. On one side, the labor unions. They would like to see high wages to maybe deter American companies from hiring non-American workers. However, on the other side, we have the technology industry. The United States technology industry is leading the world, but is only doing it because they're importing really good technology workers, primarily from India, but not just India, really around the world. The third party is higher education. These are students that are paying the higher out-of-country foreign national tuition rates to American universities so that they can enter the United States market to work for these companies in the United States. If they make the wages too high, then no one is going to hire the students that come out of the American universities, and that's going to kill American universities. So this will be an interesting point of debate to see how this comes out. If wages are raised, how high and how much of an impact will they have on the industry? One of the things to look at is that the Trump administration admitted that the data to determine what the prevailing wages were for workers that was used under the H-1B visa was good. It was accurate, right? But they wanted to artificially raise that to these really ridiculous heights, almost double of some of the jobs, right? Six-figure incomes for people coming out of college in entry-level positions doesn't happen very often. The Biden administration can handle this in a different way. Why don't you just look at the data? Let the data drive it. That would be my input, and let's see what happens on this debate. 4, if it doesn't pass, it's not over. It forces the Republicans to continue to take opposition to the immigration communities. They don't want to do this. Maybe Trump did, but a lot of Republicans that are in states like Arizona, Texas, Florida need to cater to potential voters, right? And you can't just write off an entire community and expect to be successful. You want to look at that community and cater to those who are most closely related to you and your philosophies. Writing off an entire group has not been very successful. It lost Trump the presidency, the House, and the Senate. So this forces Republicans to have to take a side. If Republicans in these traditionally immigrant communities come to the Democrat side to pass a good immigration bill, then maybe the Republicans can actually get immigrants to vote for them. Interesting to see how that'll happen. If they don't take their side, then maybe they'll just reinforce the fact that one party will serve them and the other party won't. This bill, even if it doesn't pass, will create negotiations. This bill, even if it doesn't pass, may create other bills that stem from it. We've seen Nancy Pelosi come out and already say that. Maybe this isn't the best one, but it's a great place to start. We've seen that stated in a lot of ways. This may be just political, as the Democrats don't want to lose and President Biden doesn't want to lose. But if it can create other immigration bills, that can end up being the victory on the political side. 5, this is the absolute best time to do this. Donald Trump was very, very anti-immigration. Joe Biden wants to show that he is nothing like Donald Trump. He wants to show that he is welcoming immigrants into the United States as long as they abide by the laws, work hard, and do the other things that all Americans look at as good things. Republicans are divided right now after Trump was acquitted of his involvement with the insurrection. Because of that, they may be able to pick up Republicans that think this is a good bill for the reasons we discussed above. If we were to wait any longer, then maybe it becomes more of a political football and can't get done in time, or something else comes up. Right now is the best time for this to happen. President Biden has said that immigration is important. One of the first things he did on his very first day he was inaugurated was to propose this bill. Now here we see it as the first major piece of legislation as sponsored by 2 Democrats from both the House and the Senate. So here we go. The 353-page bill is very pro-immigrant and very aggressive. Here are some of the highlights. It establishes an 8-year path to citizenship for unauthorized immigrants. It provides an expedited path to citizenship for farm workers and those who were under the DACA provisions. It replaces the word alien with non-citizen as a matter of law. It repeals the penalty of those who have overstayed for more than 180 days or more than 1 year. Those are the 3-year and 10-year bars. But at Voice of Immigration, we focus on business immigration. So I'm going to not go over all of those other things in this very, very long bill, but just go over those sections that have to do with business immigration. Here are some of the sections that impact our corner of the immigration practice. Not all are positive for business immigration and the companies we represent. For example, Section 3407, entitled Wage-Based Considerations for Temporary Workers, permits the agencies, Department of Labor and USCIS under Homeland Security, to allocate visas based on the salary. This was one of the Trump midnight proclamations and interim final rules that was going to redo the H-1B lottery in terms of who was paid the most, not in a first in, first out situation. This would be a legislative fix to that, and it doesn't just deal with H-1Bs. It is more harmful to American companies that may want to hire H-1B workers or other workers than the Trump proposed situation. Section 3405 is entitled Flexible Adjustment for Employment-Based Immigration Programs. This clause would temporarily reduce the EB2 and EB3 green cards for areas that were having high unemployment. So these 2 sections were very, very pro-American workers, right? These are pro-labor unions that may be opposed to this bill. These are some of the giveaways to get back the other pieces of legislation. These will be debated. And again, this is a bill. This is not a law. This is the starting point of the negotiations. You can see the Biden administration is giving a signal to the labor unions that we want your help on this. We will concede some issues to you. Here's one that's good for students. Section 3408, clarifying dual intent for F1 students. So F1 students don't have dual intent, which makes it very difficult for them to apply for green cards when they're going to school. They actually have to move from being students to H-1B workers and things like that. So under this scenario, if this bill was to pass into law, a student could enter the United States on day one and on day two file a green card. It takes them 4 years to get through college. A lot of the green cards can be done in that period of time so they can graduate the university with a green card. So conceivably, they could graduate and have a green card to enter into the job market without having to go through the guest worker programs like the H-1B. Here's one that's good for green card applicants for countries like India or China who have these delayed priority dates because so many of their countrymen are filing for green cards. Section 3401, non-citizens with doctoral degrees in STEM fields from accredited United States institutions will not be subject to numerical limits for green cards. What that means, if you graduate with the highest level of degrees, doctoral degrees, that means lawyers, doctors, PhDs, will not have to wait in those lines, even if you come from these countries that have a lot of these populations, as long as you obtained your degree from a United States university or college. Here's another one. Addressing visa backlogs. This eliminates the numerical limitations for those green card applicants and their beneficiaries that derive from them. This clause eliminates numerical limitations for green card applicants and their derivative beneficiaries who've been waiting in line for more than 10 years. Unfortunately, that's a large number of people, and they come from the countries like China, India, Philippines, Mexico, etc. Here's one that we don't know how it's going to play out and has been a debated clause for some time. Section 3403 eliminates the per-country caps on green card applications. The major complaint is that if you get rid of the pre-country caps, then while it will eliminate the backlog that countries like India and China have, it will create a backlog for all the others that don't have a backlog right now. So is that really better? So what's not in here is like the clause I just read that says it's going to remove the numeric limitations for those who have been waiting for 10 years. This one does not say it's just going to remove the numerical limitations. It says it's going to get rid of the per country limitations. So that means they keep the same number of green card applications, then everybody is going to have a backlog. And they'll be a very, very long time because it's so long in the countries that have backlogs. The better solution, to take a phrase from our Republican friends, let's let the market drive this. If they let the market drive it and they allow as many green cards for the business visas as there are businesses that want green cards, then they would just process these and they could process them quickly. There are people obviously opposed to that because they don't want an unlimited number of people coming into the United States. So what do? Well, you could raise those numbers. They're arbitrary anyway. What if you had them tied to how the economy was doing or unemployment, right? So if unemployment goes up, the number of green cards goes down. If unemployment goes down, the number of green cards can go up, especially in areas that are having a very, very low unemployment rate. One of the big things that occurred in the lawsuits that threw out the Trump administration's drive against immigration, because the Trump administration argued that the economy was suffering with high unemployment rate because foreign nationals were taking jobs. Well, number one, the H-1B visa only makes up 1% of the entire economy. And number two, 70% of H-1Bs are in tech. And tech, during the pandemic, had an unemployment rate before the pandemic at 2.5%, and it raised to 3% at the highest point of the pandemic. So that is a very, very low unemployment rate. That means virtually everybody is employed. So it doesn't really make sense to just have this bar if there's a real need for people to come into the country to help our American companies have the employees they need. Section 3406 is a pilot program for regional economic development. This authorizes 10,000 more green cards per year for people whose employment is essential to the economic development strategies of local communities. I'm an immigration attorney, and I'm already thinking, how can we prove essentiality to local economic communities? However, this piece has a labor certification process under the following sections of 3406B. So it seems to be intended to be a lesser version of the national interest waiver under the EB-2, because that visa doesn't require, in fact, waives the labor certification process. And that visa, under the case matter of Donisar, is really great for those who are creating jobs, right? So if this was to give people green cards in areas that create jobs, because it creates the labor certification process, we can infer that it has a process that would be lesser or less significant or a lesser threshold to prove than the national interest waiver, right? So what would that be? So first, it could be direct employment by economic development organizations, agencies of states, municipalities, counties, or tribes. They could also be companies that are affiliated with any of those local governments or partially owned by any of those local governments. They could also be jobs created in areas designated by governments, right? So empowerment zones, other areas in which the government gets behind, maybe passes a bond or passes some legislation to designate maybe an inner city or a blighted area or an unemployment area, to have that area have an inducement to jobs. Could you then argue that jobs created in this area would meet this visa classification? I think that would be step one. Here's the area that's been designated, or the entity that's owned by a government or is the government is hiring this person. And then step two is, how is this job essential or critical, right? So what would be essential or critical? Well, it comes to mind that any executives or managers that are overseeing this would meet that situation, or any of the jobs that were critical. They either created a scenario or will create a scenario that will create jobs, or basically support that premise, that mission, that strategy that local economy is utilizing. So I think the way to do it is create business plans for those communities, or look at business plans for those communities, or pitch communities that they can do this. And if they do this, they can bring in these people to help them do it. It's a really fantastic idea. I love it. I don't know where it came from, but I'm a big fan. Section 3409, H-4 visa reforms. All right, so this is really cool. This is where H-4s will get employment authorization documents. H-4s have been getting employment authorizations, but only if they are spouses, only if they're H-4s that were dependent on H-1Bs that had their I-140s approved. This now seems that it's for any H-1B's spouse or dependent. So what that means is a couple of things that are really excellent fixes to this problem. Number one, America is an expensive place to live, much more expensive than a lot of other places in the world, and it requires two incomes. Number two, and probably even more importantly, if you think about it, is a lot of H-1Bs are in their prime earning times. They are workers. They want to work. Their spouses can't work unless they can get their own type of visa, and in many instances they can't. Or they're not H-1B eligible. Maybe they didn't make it the H-1B lottery. Maybe they don't have a college degree, but they can still work and they can still do good things. And they're forced to either do it illegally or sit at home. This is a really good idea, and it's a good fix, and it's been necessary for a long time. Section 3410 are for extensions related to pending applications. This includes the H-1B, the O, the L, and the F. This relates to the F, the student visa, the O, the extraordinary ability, the L, the intercompany transferee, and the H-1B, the specialty occupation employee. Now, these people, when they do extensions after they file for a green card, they don't just get their visa extended, they get employment authorization. Well, what does that mean? So employment authorization is really cool because it's broader. That means they're not just dependent on that H-1B job, that company that sponsored them. They can only work there. This would allow them to work at other places. This would allow them to create their own companies, create more jobs. Some of our best entrepreneurs are stuck because they have H-1Bs and it's illegal for them to start another company, another job, do anything else, even if they're doing it on their own time at night or whatever. Where's the next Google going to come from? Where's the next Amazon? Well, it's going to come out of the ideas of one of these entrepreneurs, one of these foreign nationals that comes over and wants to do this great stuff. This allows them with this EAD card to go forward, launch that company, work that second job, do Uber, whatever it is, they can do it legally. So that's my breakdown of the Biden immigration bill. We don't know if it'll pass. We do know it'll create lots of debate and arguments. We do know it's really strong. We applaud its intention. I'm John Veely, CEO of Online Visas, the intelligent immigration platform where we deliver dreams.